Welcome everybody, either now or prospectively as you join us. This is the 9th floor Selborne Chambers ongoing virtual CPD seminar. Our focus today is family provision, orders for family provision made under the Succession Act 2006 of New South Wales. Our speakers today all practice in the area, some of us more regularly than others, but we all have a significant body of expertise and experience. I'll kick off talking about a recent decision from the Court of Appeal, Steinmetz and Shannon, in which the Court of Appeal considered the approach of the courts in relation to claims brought by widows, and in my view has changed to a significant degree the landscape of how we think about what is appropriate provision for a widow of a deceased. Then David Knoll will talk about family provision applicants where they don't always win, contrary to popular understanding, and he'll talk about the sorry tale of the unsuccessful cross-dressing widower. I do love family provision cases. They give rise to all sorts of different aspects of humanity. Adrian Maroya will follow with a review of evidence in family provision cases, and in particular an analysis of the Evidence Act and how it works with the Succession Act, and in particular it's section 100 or 90 or something like that. Adrian will tell us all. And then we'll finish off with a presentation by Dean Elliott on practical matters, probably the most important session that you'll listen to today, what to put into an affidavit to support an application for family provision and what not to, and a review, I hope, of the various legislative and judicial guidelines, including the content of section 60 of the Succession Act, and of course the ongoing and lengthy practice guide. So I'll start off with Steinmetz and Shannon. Let me just call up my paper. Now you'll find Steinmetz and Shannon, it's probably been reported by now, but the medium neutral citation is 2019 New South Wales Court of Appeal 114. By way of very brief background, Mrs. Steinmetz was Mr. Steinmetz's second wife, and their relationship had been a long one. She had been nominated as a beneficiary of him in the various wills he had earlier prepared, and he had updated them at various times. She'd been his full-time carer for at least 15 years before he died. And in September of 2016, when his illness took a turn for the worse, he was in hospital and was about to undergo life-threatening surgery. The doctor indeed had just informed them that Mr. Steinmetz was subject to a not insignificant chance that he wouldn't survive the surgery. And at 11 o'clock on that day, he telephoned his son-in-law, who happened to be a solicitor, and asked him to come up to the hospital with a new will. The son-in-law took instructions over the phone, prepared the will in about 30 minutes, and drove to the hospital with the newly drafted will. The will, as it turns out, made quite different and much less generous provision for Mrs. Steinmetz, and was much more in favour of his two daughters, or his two children, one of whom was married to the son-in-law. At the hospital, Mr. Steinmetz, having had the will read, asked Mrs. Steinmetz if she was happy with the will. Now, the new will left her an annuity of $52,000 a year. In the furnace of the hospital, she said words to the effect, "Yes, I'm happy with it, but I keep telling you, Jeff, I don't want anything from your estate," which was something that the court accepted that she said, and accepted the circumstances in which she said it. Although Mr. Steinmetz survived the operation, he died soon after. Now, they had been married for 5 years, but they had been in a loving and de facto relationship for nearly 30 years. And certainly the trial judge took the view that from what he called a traditional perspective, that there were some features of their relationship which he considered to be unconventional, whatever that means. The features that he honed in on were that they had tended to keep their assets separate, they each owned their own home, and they never had children together. Well, that makes me a very unconventional person, but what's more important is what happened with the Court of Appeal. And the last little bit of background is that as a result of the financial independence that they conducted their lives with, it seemed that Mrs. Steinmetz didn't know quite how wealthy her husband was. And when she discovered that his estate was in fact worth nearly $7 million, she lodged a family provision claim, and in her evidence of that claim explained how the hasty and the rushed and the unbelievably stressful events in the hospital left her in a difficult position at the time, and that she went on to explain why the annuity was hurtful to her and insufficient provision. The three judges tended to write separate decisions, although the primary judgment was written by Justice Baston. Each of Justices White and Simpson wrote separately. They were unanimous in making the point that the types of provisions that are made in wills that are considered adequate must be provisions which keep up with changing attitudes about the financial independence of women in our society today. And they condemned, all three of them, the provision of an annuity to a widow where the widow was capable of managing her own finances. They said that such a provision was out of step with contemporary society's views of women's independence. They called it, one of them called it paternalistic at worst. And then instead of the annuity, the Court of Appeal granted Mrs. Steinmetz a lump sum of $1.75 million. Justice Brereton noted in an extraordinarily thoughtful and compassionate judgment that while it was important to consider the freedoms inherent in the exercise of testamentary judgment, it shouldn't be assumed that Mr. Steinmetz's last will, which was made in the stressful circumstances of the hospital, was necessarily superior to one made earlier, which, as I'd said, is more accommodating to Mrs. Steinmetz, less restrictive and controlling. On the question of testamentary freedom, the court, Justice Brereton noted that testamentary freedom is not indeed a factor referred to specifically under the Succession Act as a matter to be considered by a court in the making of an order. And although lots of judgments talk about well, I think the misleading position of testamentary freedom in Australia, because of course nothing controls what you put in a will, it controls whether a court will adjust it after you've died. But they made the point that the concept of testamentary freedom is not a matter referred to in the Succession Act as something a court must take into account. They went on to say that the proper maintenance, advancement and education of a person seeking a family provision order is at the heart of the court's power to make an order against the express provisions in wills which provide less than adequate provision. In this case, they held for well-articulated reasons that the annuity did not meet the required threshold. On the question of unconventional relationships, the trial judge, Justice Pembroke, had afforded more weight than the Court of Appeal considered appropriate to his concept that because they had retained a substantial degree of financial independence, because they didn't always sleep in the same house, because they didn't have children together, and because they had married after such a significantly long period of a de facto relationship, their relationship was somehow unconventional. But a review of the facts suggests a different conclusion was warranted, and indeed a different conclusion was arrived at by the Court of Appeal. The reasons that they didn't always stay in the same house overnight was Mrs. Steinmetz, who was a nurse, often had very early morning work commitments, and she didn't want to disturb Mr. Steinmetz when she got up to go to work. She also didn't necessarily want to be alone in their large shared house when Mr. Steinmetz was in hospital, as he frequently was. Now, this led to a conclusion by the trial judge that there was a quality of independence in their relationship, which he plainly on his judgment considered to be a negative thing. But the Court of Appeal was quite unimpressed with this fact. Justice Simpson stated that these living arrangements may have departed in some small way from conventional norms, but that had no bearing on Mr. Steinmetz's obligation to make proper provision for his wife or the extent of that obligation. And Justice Brereton also weighed in, stating that this was not, quote, some second-class marriage. That leads me to a quick discussion of community standards, because that was something considered and importantly considered by the court. This phrase doesn't appear in the legislation, but there've been a long line of cases in New South Wales that suggest that a judge should consider community standards or community expectations to determine whether an applicant has been left without adequate provision. Justice White in particular raised concerns about the use of the concept community standards, and he noted that it's unclear whether that concept refers to community generally or to a more particular cultural, religious or ethnic community, such community in which, as the applicant for provision might reside. I think it also becomes a problem when, for example, you have a religious family. The deceased might have quite strong and conservative religious views, but they may not be the same religious views that his, let's just use a gendered example, that the widow might hold, or that the deceased children might not be so conservative in a religious way. Whose community standards would you expect to be applied? Would they be the community standards of the deceased, or the community standards of the applicant for provision, or the community standards of the judge? Given that all three sort of standards can be and are intensely subjective, you start to see a problem there, particularly in the increasingly diverse society that Australia is sort of plainly made up of. So the question would be, how would you deal in or factor with those values to inform? Justice White suggested that community standards shouldn't be a standard that an applicant or a defendant should aim to prove, using the analogy against that as the reasonable man on the Clapham omnibus. Instead, Justice White suggested that the concept of moral duty might have more use than the concept of community standards. In this, Justice Brereton agreed, although he was a bit more ambivalent and suggested, I suggest practically, that the two are probably the same thing, still heaped with problems. But the attractiveness of considering a moral duty is also increased as the legislature does seem to have intended it, at least in slightly different words. Justice White picked up on the section 60 subsection 2B of the Succession Act, which is the list of matters that a court must take into account. And that subsection talks about the nature and extent of any obligations or responsibilities owed by the deceased person to the applicant. This sounds like, and gives effect to, an intention that the court consider the extent of the testator's moral duty in determining whether a family provision order is appropriate. Now, experts in this area will remember that there has been a deal of discussion, much of it negative, about the idea of importing a moral duty to understanding what's expected of a testator. I haven't seen anything which picked up on this further articulation, but it's something to hold on to as something that we may see more judicial discussion about. And then finally, on financial necessity, the court was also critical of an approach which dictates financial necessity or need as the primary consideration in determining whether a family provision order should be made. And this also came back to what's set out in section 60 and its various subsections. Financial necessity is one of the factors that a court is to take into account. And the reality has been that in the past, most courts or most cases have used the concept of financial need as a shorthand and directed most of their attention just to that aspect of the list. But the court in this case pointed out that it's not at the top of the list, and the list sets up all the other sections equally. And so financial necessity is a matter to be taken into account, but it doesn't necessarily take precedence as one of the factors. It's really an assessment of the omnibus words, the proper maintenance and advancement in life. So I recommend a close read of Steinmetz. It's a well-written judgment. It's you know, one of the strongest judgments I've ever read from Justice Brereton. It's been suggested that he's taken a kind of a family law approach to it. Certainly that is the view, I think, that some of the people who act for executors tend to think, but the reality is it's a strong unanimous judgment of a powerful Court of Appeal bench and something that will factor into the way we think about these types of cases. So without more ado, can I introduce David Knoll, who will talk about the sorry tale of the unsuccessful cross-dressing widower. Over to you, David.
Thank you. As Payne has explained, it was for a long time a conventional wisdom that applicants for family provision, especially widows, widowers and children, would usually get some portion of the claim that they made on an estate. That's no longer the case. The Supreme Court has become more willing to reject claims in recent years. And practitioners need to keep in mind that it's only if the court is satisfied of the inadequacy of a provision by the deceased, which brings us to this moral duty question you've just heard about, that consideration is given as to whether or not to make a family provision order. And you don't have to go too far back, but to Andrew and Andrew, which is reported at 2012-81 of the New South Wales Law Report, 656, then President Allsop just made that point at page 658. But even widows and widowers, we have to remember, they're the people for whom the original testator's family maintenance was introduced. But they have to provide persuasive evidence. Now, the case of Economou and Panagopoulos, and I'll spell it for you for those who've got their pens, Ikonomou and Panagopoulos. The medium neutral citation is 2017 NSWSC 1805, was one of Justice Parker's early family provision decisions. It concerned a widower who owned the matrimonial home in equal shares as tenants in common with his deceased wife. Manuel was the husband, and he was 17 years younger than his wife, Helen. They married back in August 1977, and she passed away in June 2016. It was Manuel's first marriage, but Helen's second, and she had a daughter, Nancy, from her first marriage. Helen made her last will in February 2014, some 2 years before she passed, and she appointed Nancy as her executrix, and she left the whole of the estate to the granddaughter, Elena. The estate was worth around $700,000. Manuel, through his counsel, came to court and he sorted a crisp order. Now, a crisp order, for those who don't recall, is an application for an interest for life in real property or an interest in real property with a right, should the need arise, to secure alternative accommodation like a retirement home or a nursing home. That was the emphasis of the applicant's case, and you'll quickly see why it was that Justice Parker didn't even refer to it when he gave reasons for judgment. Manuel and Helen, it turned out, quarrelled frequently, and Helen spent half of each year as she got older in Greece with relatives, and only on one occasion did she take Manuel with her. He slept in a separate bedroom, and Nancy gave evidence that he was a very active cross-dresser. There was quite detailed evidence of a room full of ladies' clothes, makeup and sex toys. He was also a very proficient hoarder. The matrimonial home was in an appallingly cluttered state. The only exceptions were Helen's room and part of the kitchen. All of Helen's bank statements went to Nancy's address. And in November 2012, when her faculties began to decline, she gave her daughter an enduring power of attorney. In April 2015, she suffered the first of 2 strokes, and while she was incapacitated, both Nancy and Manuel went to the New South Wales Civil and Administrative Tribunal to become her guardian and financial manager. The tribunal handed guardianship to the public guardian, but left Nancy in charge of her mother's financial affairs. Despite all that, Manuel, the applicant, a widower, 66 years old, living only on the pension, thought he had a very good claim. But As it turned out, because the marriage was a marriage in name only, the court focused on subsections 62A and M of the Succession Act, which is the list of factors that the court needs to look at, particularly the nature and duration of the relationship and the character and the conduct of the applicant before and after the date of death. Manuel, by the way, also refused to contribute to Helen's funeral expenses. One piece of evidence, and I know Dean's going to talk about evidence later, was crucial in persuading the judge to make no provision at all. There was a document filed with Centrelink in October 2015 after Helen had had 2 strokes. It was entitled Relationship Details Separated Under One Roof. It purported to be signed by Helen at a time when she could no longer sign after 2 strokes. On the form, Manuel acknowledged that they had no sexual relationship, but the form asserted that Helen was doing the cooking when it was quite clear she couldn't do so. Manuel even pretended to be Helen and stated on the form in his broken English, "As my vision decreased, I come back to Manuel." And all this in circumstances where since 1992, Helen had the single pension, and when Manuel was eligible for the pension, he also applied for a single pension. So this form was an application to switch from single to partnered, and Centrelink didn't process it as it turned out. The problem for Manuel was that he also couldn't produce any financial evidence that he contributed to the purchase of the matrimonial home. Nancy's evidence was that Helen paid for everything. So although he was a tenant in common, it would appear that he didn't actually pay for the house. And the court took that as a provision during lifetime to Manuel by Helen. If one wonders what about the will, here is what the will relevantly said. "I note that in making this my will, I have borne in mind the interests of my husband and state that he is to take no part in my estate other than the right of occupancy mentioned in Clause 3. Clause 3 gave Manuel 6 months after Helen's death to reside in the matrimonial home in Cronulla before it was to be sold." Helen had the same provision in an earlier will made in 1999. So there were other details, some more, some less salacious. It was certainly a case where the judge didn't blush, but other people in the courtroom did, which was not determined solely on the question of need. And this is the important part. A case determined solely on the strength of provisions made by a spouse in a will has to take into account provisions made during the deceased's lifetime. And here it became fairly obvious that all or most of the interest as tenant in common that Manuel had in the house was in fact a contribution by Helen. Nor was it a case where separated partners living under one roof had finalised their financial relationship, as in the now famous case of Loden and Loden, which is 2017 New South Wales Court of Appeal 327. It is more a case where the court determined that Manuel didn't even get to the threshold that the court could find that there was some moral duty to make provision for him in the will. Colourful as it was, one can paraphrase the words of Justice Ward, as Your Honour then was, in Scott and Scott, and if you want the paragraphs, they're very useful in almost any one of these types of cases. It's at 2009 NSWSC 567. The relevant paragraphs are 136 and 137. She actually did refer to community standards, interestingly enough, and she said the community would consider that a testator in the deceased position had already done the right thing by effecting an amicable division of the principal asset, the house. And that was indeed what Justice Parker found against Mr. Manuel Economou. The last authority I'd like to draw your attention to, apart from Scott and Scott and Economou, which makes for interesting reading, are the comments of Justice Lindsay in Verzar, that's VRZAR, 2012 NSWSC 1380 at 131. And His Honour said this: "Whatever guidance one might draw from analogous cases, all analogies and any guidelines drawn from a pattern of similar cases must yield to the text of the legislation, the duty of the court to apply that text to particular circumstances and the totality of material circumstances of each case. Preconceptions and predispositions, comforting though they may be, can be the source of inadequate consideration of the jurisdiction to be exercised." I mentioned earlier that this was one of the earlier decisions of Justice Parker. A later one, 2 years later in fact, and I'll spell the names for you again. Megedichian, Megerditcian, and Katurian, Khatadeurin. It's a 2019 NSWSC 1870. The citation is easier to write than the names. Was a daughter who made a claim on her 91-year-old father's estate. She'd been left $10,000. Her brother was to inherit the residue, and the estate was worth about $900,000. The house had already been transferred to the brother. The daughter came to court wanting an equal share of the estate, but with very limited evidence. In the end, His Honour made a notional estate order and provided that she should receive a legacy of $100,000, which turned out to be just over 10% of the estate. The case is an interesting read because it sets out how not to prepare and run a Family Provision Act case. If ever there was one where a judge gave guidance on how to put your case together and how not to do it, Justice Parker's done us all a favour in this particular one. So with that reference to the need to make sure that an applicant's got his case together before commencing or before she commences, I'll hand over to my colleague and friend Adrian Maroya to address you on aspects of evidence in FBA cases, the Evidence Act and facilitation of proof.
Thank you very much, David. I think that you've made my presentation sound a little bit grander or extensive than it actually is. I'm actually dealing with a rather discrete aspect of evidence in these cases, and I'll endeavour to explain as simply as possible just what that is. Recently, I had occasion to look at the decision of the High Court in Hughes and National Trustees, Executors and Agency Company of Australasia Limited, citation for which is 1979 143 Commonwealth Law Reports 134. Hughes's case concerned an application for family provision by the only son of a testatrix. The lady, who was advanced in years, had left the whole of her estate to various causes. Her son, who was her only son, was aged 54. While he was able-bodied, he had virtually no assets and he had no income. On an application by him for family provision under the then Victorian statute, he was met with an allegation in response that he had engaged, as regards his mother, in disentitling conduct, such as to render him disentitled to any provision from the estate. That was a question that was ultimately determined in Mr. Hughes's favour by the High Court. The point of interest for us here today is that certain statements made by Mr. Hughes's mother were received into evidence on the question of disentitling conduct, namely the extent to which, and I suppose to the effect in terms of what the statements actually drove at, to the effect that Mr. Hughes had driven the testatrix from her own house on her own land. One of those statements was made by Mr. Hughes's mother in explanation of her reason for not having made any provision for her son in her will. When it came to deciding the question, the majority of the High Court, which was constituted by Gibbs, Mason, Murphy and Aiken, Barwick CJ was in dissent, but not on the point concerning the admissibility of Mrs. Hughes's statements. The court concluded in essence first that statements made by a deceased about the misconduct of an applicant for family provision, although not admissible to prove the fact of the misconduct, are admissible to provide some evidence about the reason why the deceased had not disposed of her estate in some particular way. The second aspect of the High Court's conclusion in Hughes's case was this, that because such statements are not admissible to prove the truth of their conduct, their reception into evidence doesn't shift the burden of proof of disentitling conduct away from the party relying on the statement. Thirdly, an applicant who fails to deal with the statements that have been tendered in that fashion against him or her will not be taken to have, by inference, admitted the truth of the statements. Now, in terms of the legal context as it existed in 1979, Justice Marnie's reasons in the case of Towse and Elton, which is in 1974, 2 New South Wales Law Reports 163, those reasons show that the High Court statement in Hughes's case reflected really to a very large extent the state of the common law in New South Wales before the enactment of the Family Provision Act 1982, which by Section 32 attempted a statutory encapsulation of the majority's view in Hughes's case about the evidentiary effect of a deceased's statements. I add in passing that Justice Marnie's reasons for judgment in Towse and Elton are a very useful, informative survey of the position as it existed at common law. Now, Section 32 of the now repealed Family Provision Act 1982 is in identical terms to the present Section 100 of the Succession Act 2006, save for a little streamlining of language. So cases that concern the effect of Section 32 of the 1982 Act are equally relevant to the present situation under Section 100. It's fairly common to see in the cases dealing with family provision matters references to what are usually called Section 100 statements, by which a testatrix has purported to give reasons for particular testamentary dispositions. I think that before the statutory codification of this discrete aspect of the law of evidence, it often used to be the case that statements by a testatrix were tendered as happenstance pretty much engendered the making of those statements as they occurred in real life. While that may still undoubtedly be the case, I think the modern tendency appears to be for statements to be made by a testatrix at or around the time of the making of her will, by which she intends to leave a contemporaneous statement of her wishes and her motivations for the testamentary disposition that she in fact made. Now, if that is the case, I think greater attention should be paid to the stipulations of Section 100 so that any statement of intention better reflects the statutory requirements for the admissibility of those statements and better serves the fundamental purpose of such Section 100 statements, which is to be, that is, basically, those statements have to be received into evidence if necessary, and secondly, they need to survive curial scrutiny. So with that aim in mind, I'm going to turn to a very necessarily brief examination of the main features of Section 100. Now, the first and perhaps the most important aspect of Section 100 is that evidence of a statement made by a deceased person is admissible as evidence of any fact stated in it of which direct oral evidence by the deceased person would, if that person were alive and able to give evidence, be admissible. It's important to note that Section 32(2), as it then was, now subsection 102, was interpreted by Justice Young in a case in 1991 called Purnell and Purnell, which is in the New South Wales Law Reports, as only operating to make admissible an oral statement by the deceased person about whose estate the court is concerned, not any other deceased person somehow involved in the factual narrative. So that would exclude, for example, if both former spouses had died and the court were concerned with the estate of the wife, only a statement made by the wife about her will with regard to any third party somehow affected would be permitted to be adduced into evidence. A statement made, say, by her late husband would not be the sort of statement that would be able to be received under subsection 102. It seems like a stark result, but that's how Justice Young interpreted it and explained it in Purnell's case. And it's to retain focus upon the estate, or rather the deceased person with whose estate the court is concerned. The second aspect to bear in mind is that where a statement made by a deceased person during the person's lifetime was made otherwise than in a documentary form, no evidence other than direct testimony, including oral evidence, evidence by affidavit, and evidence taken on commission, is admissible other than evidence given by a person who heard or otherwise perceived that statement being made. So there needs to be a living link, if you like, in terms of this second-hand species of evidence between the original maker of the statement and the person who was giving evidence to the court about that issue. There's an exception to this rule where a statement was made by a deceased person, obviously enough during that person's lifetime, while giving oral evidence in a legal case. That statement may be received in any manner that's authorised by the court hearing the family provision application. I think, even though the section rather unhelpfully is fairly opaque in its terms, I think it might be presumed here that a statement made by the deceased person will have been transcribed the court proceedings in which that person gave evidence. And if so, it's probably likely then that an official transcript of the evidence might be able to be tendered. If not, I think that the subsection envisages alternative means of proof of the fact of that statement, and it doesn't really prescribe or spell out what those alternative means might be, save for saying that it must be done with the approval of the court. Now, there are in cascading order in the subsections of section 100 various more procedural matters. One thing that I will say briefly in the time that's left to me is that once a statement of this sort has been received into evidence, the court is enabled really to do two things. It can draw any reasonable inference from the circumstances in which the statement was made, or from any other circumstances that are relevant, including in the case of a statement that's contained in documentary form, the form or contents of it. Secondly, the court has to embark upon an assessment of the weight that might be attached to evidence of statements received in this form, and it can look at specifically two things. First, the recency or otherwise at the time when the deceased person made the statement of any relevant matter that's dealt with in that statement. And secondly, the presence or absence of any incentive for the deceased person to conceal or misrepresent any relevant matter in the statement. And there are two simple reasons for that. The first is, for example, that reasons can be shown to have been correct, or somehow the factual bases that underpin the reasons might have been misunderstood by the person making the will. Those factors can enhance or boost the strength of the defence of a claim, or some statements, and this has received some recognition in the cases, some statements may be more in the nature of a hasty remark than a considered rational expression which sheds light on why the testatrix made the will in the particular form that she did. There are many other matters that I would like to tell you about, and perhaps for reasons of time, which is rapidly vanishing before my eyes, I might say this. If any of you are interested to get a sort of précis of what Section 100 says, please send me an email and get in touch, and I'll send you a short outline that I've done. I'll say one more thing about all of this, and it's this. There is a rather obscure interface between Section 100 of the Act and the rules that constitute exceptions to the hearsay rule in the Evidence Act 1995. The Evidence Act hearsay exceptions are perhaps a little broader than those contemplated by those in Section 100. So I think the two schemes need to be read in a complementary fashion and not in isolation from each other. And that's why Professor Dalpont, in his most recent edition of his Law of Succession, makes the valid point that someone in the parliamentary draftsman's office should give consideration to incorporating this aspect of the law of hearsay into the Evidence Act 1995, rather than have it sourced in two completely different areas. That concludes my very brief and truncated consideration of what is really a fairly important section. It doesn't ping very high on the Richter scale of excitement, but it is very, very useful to know. And that brings me to commend to you the presentation about to be given by my colleague and friend, Dean Elliott, who is very experienced in not only the presentation of family provision applications in court, but gives his instructing solicitors very hands-on and very helpful advice in the actual physical preparation of what ends up being dished up in court. So over to you, Dean.
Well, thank you, Adrian, and hopefully I'll live up to that description. I'm going to talk about affidavit writing in FPA applications. Now, this is something that I could spend an hour talking about, but I've got 10 minutes and I will stick to that. So I'll keep it essentially practical, and I'll talk about 3 points. Firstly, what's required under the statute and practice notes. Secondly, just some practical areas which I think should be expanded upon, or people should focus on in their affidavits. And thirdly, just some tips on affidavit writing generally. And I'm sorry if the last topic is particularly annoying, or I'm telling everyone how to suck an egg, but the first thing I think that you need to think about before you even start writing or drafting an affidavit is, what is it that you are trying to establish in the proceedings? And that requires you to look at the relevant statutory framework as to what evidence needs to be led before the court in order to get to the result that you want. And quite often as solicitors, a client will often provide you with a statement that they have prepared in advance that has got absolutely every possible thing that they could think of in it. And often the starting point is that people will cut and paste that document into an affidavit and then just try to work it into a structure which flows. But the important thing before you do that is to think, what does the court need, and what is it I'm trying to establish? The first thing you need to show in Section 57 is that the applicant is an eligible person. Now, there's a list in Section 57A through F as to who the eligible persons are. The first 3 in the list, being the spouse, the de facto, or a child, they are natural objects of testamentary disposition or recognition, but the later 3 are not. And as we know from section 60, section, I have it here. In section 57, you also have to show factors warranting for former spouses and people that were wholly or partly dependent on the deceased, or grandchildren, or those living in a close personal relationship. And the evidence needs to address the features of that relationship that can be said to create a social, domestic, or moral obligation on the deceased to make testamentary provision for the applicant. And that's the Court of Appeal of Loddon and Loddon 2017 NSW CA 327 at 129. So first point, need to establish an eligible person, and then within the 6 types of eligible person, you need to determine whether factors warranting need to be established or not. That then takes you to the matters that need to be in the substantive affidavit. The good starting point, of course, is the practice note, which you'll find on the Supreme Court website, and that sets out all the particular factors under headings in section 60 of the Act, and the things that the court will look at when making an order. Now, in addition, the practice note also sets out matters which are not subject to formal proof under the Evidence Act, and this is often to do with valuation of assets of the estate, and also the plaintiff or the beneficiary's estimate of costs of items that they wish to acquire for refurbishment of property, and also evidence of any physical, intellectual, or mental disability. And in that case, a simple letter from a doctor will often suffice, as opposed to a full-blown medical expert report. It's something worth considering as well when you're preparing your evidence, but also whether when considering evidence of your opponent, whether it be a plaintiff or other beneficiaries in the estate, whether you want to put them technically to proof on the matters where they're relying on informal proof under the practice note. If you do, that can have obvious cost consequences if you put them to proof on something which they've attempted to prove informally in a cost-effective manner. Now, I won't go through all the factors set out in section 60. You can do that in your own time. But it is one particular comment to make. It's important for an applicant in a family provision application is to make full and frank disclosure of their financial and material circumstances. Now, that doesn't mean just identifying, for example, if they have liabilities, not just saying what they are, but also identifying how it is that those liabilities have been accrued. To say, for example, someone has a debt of $100,000 to the bank, or credit card debts, the court, when making disclosure of that, consideration should be given as to what you tell the court as to how that debt has been incurred. Has it been because over a number of years, the income versus expenditure, or sorry, the person's just general living costs are greater than their income, such that they've amassed a large debt over a number of years? Or is it the case the person has a gambling problem and the debt sitting there is liabilities occurred due to gambling? Or so one needs to give consideration to if there are liabilities that are being disclosed, as to disclose to the court and give information in relation to them. The other point as well is, for example, if any of the plaintiff, or in that case also the beneficiaries of the estate, if they are on Centrelink benefits or have access to pensions, something to consider is not only what pensions they are entitled to, but what the effect of a family provision order will be on those those entitlements if they if a plaintiff is successful in obtaining an order, or and therefore their assets are increased, and also the effect that it may have on the beneficiary of an estate if they are subject to a Centrelink order or something like that. Now, the other point to know as well is that in terms of when stating what a plaintiff wants or requires for his adequate and proper provision, the affidavit is not a wish list of things that they would like. It's often a consideration based on needs as opposed to wants. That will often, of course, depend on the size of the estate. A very small estate can often only provide very limited provision, and therefore you need to adjust what you are seeking based on the size of the estate, the ability of the estate to make provision, but also considering the circumstances of the claimants on the estate as well. So the court will not only look at the financial circumstances of the plaintiff, and of course, as for reasons mentioned before, they will need to be disclosed, but also the financial position of any beneficiaries, because at the end of the day, any provision that comes from the estate will be taken out of the pockets of the existing beneficiaries and provided to the applicant. So quite often, in addition, the testator may have had reasons for leaving the estate to the beneficiaries, and in many cases you will see that it's because one of the beneficiaries or collectively the beneficiaries are in a poor financial state, and then the plaintiff is in a much better one, so the full financial circumstances of both sides of the ledger need to be considered. And the last point I will just speak very briefly on is affidavit drafting. Now, in the past, evidence used to be given viva voce. A plaintiff would be put in a witness box and the evidence would be deduced orally. That is now being done away with, and the practice of the Supreme Court is to take evidence by way of affidavit. Now, the affidavit should be in the plaintiff's own words and language, and one needs to be quite careful when drafting these affidavits to make sure that they don't, as a solicitor, use their own language as opposed to words and phrases that a beneficiary, that the party would use. So try to draft the affidavit using their own language. Obviously use clear headings. Try to present the information in a chronological order if you can. Only include information that is relevant to the claim, and that comes back to my first point about the need to assess, or what is it that you need to establish, what evidence do you need before the court, and what do you need to prove in order to be successful in your claim. It's very important to test what the client tells you as well. Quite often you will read these statements. It's very important to qualify or seek to understand what you are told, and to identify any inconsistencies in what you're told early on, as opposed to doing nothing and then watching it unravel, as it were, in the witness box. The other thing that I've noticed often in affidavits, which is quite often very generic conclusatory statements are inserted into affidavits, and while when reading an affidavit they may assist in painting a story, one has to be careful to make sure that what is put is compliant with the Evidence Act, because if an affidavit has got sort of conclusatory statements where the source of the knowledge which sits behind those statements is not disclosed in the affidavit, then there's a very good chance that objection could be taken by the other side and the evidence thrown out. So it's very important that if there's a statement if you're preparing, for example, an affidavit based on notes given by the client, and they've stated a particular proposition, how is it that they know that? Did they hear it? Did someone tell them that? Did they see it for their own eyes? What is the basis of it? Is it hearsay? Is it not? Again, and that sort of, the same goes for opinions on matters. Again, stick to the primary facts. What evidence can you give that is within your own knowledge based on things that you have heard or seen or otherwise perceived, as opposed to sort of motherhood statements, which can lead to them being knocked out in evidence. Unless there's any questions, that's what I have to say about drafting affidavits.
Thank you, Dean. And thank you too to Adrian and David. There's been a little bit of chat during the presentations. Those of us who have spoken from a prepared outline will, as best as I can tell, certainly I will, and David has offered, I think the others probably will as well, we'll upload those outlines onto a couple of different platforms. Depending on our technical skills, we'll load them onto the floor's LinkedIn profile, we'll load them onto the floor's website, and if all else fails, if you send an email to our clerk, Ed Brown, not Adrian, who's also Ed Brown, but Ed Brown himself, he'll be able to send you an email. You may need to give us a couple of hours just to get the various documents together. We're obviously not all in the same place as you aren't either, but we'll get those to you. Does anyone have a question that they want to ask from the floor? Now's your opportunity. We've got a few more minutes. Adrian, I do have one. When you have combined proceedings, so you might have an application under the Succession Act for provision, but that may also be tied up with an application under the Trustee Act, for example, or an application under general law. How do you pick through the leeway given under the Succession Act, Section 100? How do you limit that from tainting, if I might, the non-Succession Act proceedings?
I think, Michelle, the only straightforward answer to that question, but it's probably relatively correct in terms of the guidance that it might give, is that you can fall back on the state of the common law as was summarised in Hughes and the National Trustee Executor and Agency Company case. That is basically that a statement of this sort, when it's received by a court, first of all, can't be used as the truth, or rather used as material or evidence going to the proof of anything which is asserted in the statement. And that situation obtains equally under the regime now contained in Section 100 of the Succession Act. But I think that where you've got a question arising on the terms of a testamentary trust, say, I think that there you're dealing with a whole different range of interpretatory techniques, if you like, or a completely different sort of canon. So I don't think that the fact that a statement by a testatrix, as was the case in Hughes's case, the fact that a statement like that is admitted for a family provision purpose is necessarily going to be something that causes difficulties for anyone when it comes to the interpretation of, you know, a trust deed or anything like that. And also bear in mind that there's a rather complicated range of provisions or safeguards in the various subsections of Section 100 that enables someone on the other side, if you like, of the bar table of such a statement to be able to effectively take issue with what is asserted in the statement. The only a problem that can arise is that if you start embarking on an inquiry, which if the person who made the statement were there in court giving evidence and you were effectively cross-examining that hypothetical person on a matter going to credit, I think it's subsection 110 of section 100 says that you're stuck with the answer that inquiry leaves you with if you're simply trying to attack the credit of the now dead maker of the section 100 statement. So it's a very complicated little range of issues, but I think fundamentally its use would be restricted to questions going solely to the family provision aspect. And if you weren't satisfied about that, you could ask the judge to make a limiting order in any event under the Evidence Act 1995 to ensure that evidence going to that issue, the family provision issue, weren't able to be used on any other issue in the case.
Yeah. Okay. Thanks, Adrian. We're rapidly running out of time. We intend to keep these sessions going probably every 3 weeks and maybe even once a month. But we'll keep sending out invites until you tell us not to, till you're so sick of us you don't want to see us again. We also are very keen to know if there's any topics that we can address that you're more interested in. We think the next session will have a relatively specialist insolvency focus, particularly with the rapid approaching of the end of provisions designed to help us get through the shutdown, the holiday, as it were, from directors' duties in some senses. But we cover almost every aspect of commercial law. So we are happy to tailor a discussion to an area of interest. Do get in touch with us. All of our details are on our website. You can usually phone the barrister directly or go through our clerk Ed. Most of us are terribly approachable and nice people and would welcome a discussion from any of you. But thank you all for your attention, and we hope to see you all in a few weeks. Thanks again. Bye.